Hello and welcome. In this session, we're going to discuss the Supreme Court of the United States, as well as the Chief Justices of the United States Supreme Court. My name is Thomas Keith. I am an assistant professor of humanities at the Rocky Mountain College of Art and Design. And let's begin. The Supreme Court was created under Article 3 of the United States Constitution. When it first met, it did not really assert itself very much. In fact, it was not considered to be a co-equal branch of government. Symbolically, the fact that they even met for so many years in the basement of the United States Capitol kind of tells you symbolically what people thought of it, that they were subservient to the other branches of government. While there were early precedents of judicial review, the concept did not become as significant the way we know it today until the rule of the fourth Chief Justice, the famous John Marshall. The first Chief Justice of the Supreme Court was John Jay. He's famous for being an author of the Federalist Papers, the signer or a negotiator for the Jay Treaty, as well as a famous founding father of the United States. He was nominated and confirmed. He was nominated by President Washington, who has the distinction of nominating maybe 3, if not 4, Chief Justices of the United States Supreme Court. Under the Jay Court, there was the first decision ever, West versus Barnes, a Rhode Island tenure case about paper money, and then the famous Chisholm versus Georgia. I'm going to discuss some of the cases in more detail than others. Obviously, you can pause this at any time and look them up, take screenshots. It would be incumbent upon you to make a complete list of the cases that are listed here in this slideshow. The second court is the Rutledge Court, the shortest court ever, the only Chief Justice to receive a recess appointment. And there was one notable case that came out of his tenure, and that was the Talbot versus Jansen, the concept of multiple citizenship, that by becoming a citizen of one country, you don't necessarily renounce the citizenship of the United States. The Ellsworth Court is the third court. He's the one that really got us going in this precedent of writing consensus decisions. The Supreme Court has 9 members, and there is what's known as the majority opinion, and then there could be a concurrent opinion with the majority, and there's often a minority opinion, and there also could be a concurrent or a concurring minority opinion. Now, Marshall. Have I mentioned he's a big deal? Hey, guess what? Marshall, big deal. Hey, guess what? Marshall's a big deal. He's really credited with establishing the Supreme Court of the United States as a co-equal branch. Unfortunately, with all of his successes and his longevity, I think the big point that I'd like to accentuate is the fact that he was not able to get Jackson to enforce. Worcester versus Georgia is a dangerous precedent that other presidents have contemplated following. Here are some of the decisions that came out of the Marshall Court. Marbury versus Madison is probably the most famous one, but I would make sure that I knew all of the cases on this page here if I was taking any kind of a government test, an AP government test, a college government class, or have you. The next Chief Justice was Roger Taney. He is most famous for his decision in the Dred Scott case. In fact, the Dred Scott case is one of the only cases that's known just by one of the parties in the case and not the full us versus them. Dred Scott, as most of us know, is a horrible decision, and it is a sin on the legal history of this country. Taney did have it also, similar to Marshall, his predecessor, a very long tenure. He's most noted for being the first Catholic justice of the court. Famously today, they call the Supreme Court the Catholic Court because it has a majority Catholic constituency. And he has the reputation and the note of establishing or giving the oath of office to 7 U.S. presidents, more than any other Chief Justice. We're going to go through a few less famous justices now. The court under the leadership of Salmon Chase, had a couple of interesting decisions, but I think that I'd like to just point out there that the fact that he dismissed Jefferson Davis versus USA is a pretty interesting trivia fact in U.S. legal history. He's also the first the first Chief Justice to preside over the impeachment trial of a president. And that would be the Andrew Johnson impeachment trial. Then that's followed by the Waite Court. You'll notice these cases are pretty famous here, the slaughterhouse cases in particular. He overworked himself. As an anecdote, he was considered to be one of the less intelligent Chief Justices and one of the hardest workers, and as a result had a breakdown. He did interestingly recuse himself from the constitutional crisis of the election of 1876, when the Republican candidate Hayes lost the popular vote and the electoral vote. Samuel Tilden, the Democrat, won both of those, and then Congress reinvestigated and ultimately reapportioned 15 electoral votes, which gave Hayes the win. The Chief Justice, Waite, he had actually gone to college with one of them and was friends with the other, so he was not party to that decision. The Fuller Court has an interesting, and here I start a pattern that you'll see I'll continue later, where I have Gonzalez versus Williams as an accomplishment as well as a liability. It is unique in that the decision affirmed Puerto Rican citizenship but did not declare citizenship, if you can follow that. What the court decided is that you couldn't bar a Puerto Rican coming to the mainland because they were part of the United States of America, but did not explicitly declare citizenship. That came legislatively, probably about 15 years later. He is interestingly also the author of a couple of phrases we use all the time: equal justice under the law, and also we usually say separate but equal. He actually wrote in the Plessy case equal but separate. He's followed by the White Court. Interestingly enough, White was a Democrat but was elevated by a Republican, President Taft, and then following White's death, Taft was appointed by his successor, making White the only Chief Justice to be followed in office by the President who appointed him. Thus, we have the Taft Court, the only U.S. President to be Chief Justice. The Hughes Court, actually I'm laughing because Hughes thought he was going to be Chief Justice at least one time earlier, if not two. Thank goodness he lasted as long as he did, so he did get onto the court. The most notable accomplishment, from my perspective, of Charles Hughes is the fact that he was able to, behind the scenes, block FDR from packing the court and kept the number at 9. He's followed by Chief Justice Stone. Unfortunately, Karematsu versus the United States was decided by the Stone Court. In my opinion, that's one of the worst decisions of the United States. It's up there, in my opinion, with Plessy versus Ferguson and Dred Scott. The fact that a U.S. citizen was detained in an internment camp is, again, one of those dark marks in our legal history. Interestingly, he's the only justice. He actually progressed through the positions. He was nominated to the Supreme Court and was an associate justice, and therefore the junior most justice, and actually went up from seniority from being junior most to 8, 7, 6, 5, 4, 3, 2, 1 Chief Justice. He's followed by Vinson, the last Democrat to be nominated and confirmed to be the Chief Justice of the United States. The Warren Court, probably one of the most famous courts. I would say the Warren Court is probably the second most famous court, in my opinion, after the Marshall Court. And you can see the length of cases. The Warren Court dealt with a lot of civil rights cases as well as civil rights. I'm sorry, I said that already. What I meant is racial civil rights as well as individual civil rights in terms of search and seizure and Miranda versus Arizona and such like that, and the right to get married, Loving versus Virginia. Make sure you know Warren. Big deal. He's also the chairman of the Warren Commission, which investigated the assassination of President John F. Kennedy. He's followed by Berger. Warren Burger, the Burger Court, probably known as one of the least liked Chief Justices of the United States. He might even be up there with number two there in terms of not being very well liked. By the time of his retirement, he had no friends left on the court of either political party. His notable accomplishments is sticking up for the judicial process under the case of USA versus Nixon, and that Nixon had to turn over those tapes. And then you can see here for Roe versus Wade, I put that under an accomplishment and a liability because obviously it's a very sensitive topic and people have very strong opinions. I put under worst with an asterisk because I understand some people might disagree, but in my opinion, it's a bad case, and I think you can look legalistically how it's been. Gregg versus Georgia has been watered down since 1976 when they reinstituted the death penalty. They've slowly been putting more checks against the death penalty in the United States. Lynch versus Donnelly is an important case, comes up every Christmas time. It's the Kresch case. And the United States Supreme Court decided that it is okay to put up religious paraphernalia, but you cannot put exclusively the religious paraphernalia of one religion. It either has to be open to all religions or cannot be open to any one. And so similar to what I said here about how Roe v. Wade and even the death penalty cases can become really controversial and personal, and it's current events to a lot of Americans. A lot of Americans were alive during these decisions. So for the next two courts, the Rehnquist Court and the Roberts Court, I did not separate them into good cases and bad cases. I just lumped them together as notable cases. Planned Parenthood versus Casey is probably the second most important case in terms of abortion in the United States. It put some limits on abortion, but maintained the legality of it. Because it maintained the legality of it, Rehnquist himself dissented. Roma versus Evans was an attempt by the state of Colorado to protect the rights of gay citizens in Colorado. It was actually struck down, and that was a decision which Rehnquist concurred with. And then we have Dickerson versus the United States, which is also a gay rights case, and Rehnquist voted against extending rights to gay Americans. His argument was from a strict constructionalist perspective, that there was no, that homosexuality was not listed in the Supreme Court. Probably most famous for the Bush versus Gore decision, which, if you look at the membership of the court at the time, they all voted the opposite of their espoused ideology. You had the Democrats who voted to protect states' rights, the state of Florida to count the votes, and you had Republicans who espouse a states' rights philosophy who actually argued and decided with their majority that the federal government had the right to end the vote counting process. He is known historically as the second, and only the second, Chief Justice to preside over an impeachment trial. And famously, and he's kind of mocked for this as well, he put chevrons on his judicial robes during the trial. I don't know, trying to make a fashion statement, I guess. And currently we are during the Roberts era. We have the Roberts Court. He is the 17th Chief Justice, and you can see that there's a long list of court cases there, and he's mocked because he did mess up the oath of office to President Obama, so much so that they did a redo the next day, which was equally mocked. I think that when we get historically further from these court cases, we'll be able to kind of hash out which ones are the more important than others. But you know, you have a couple of cases. You have the decision that the federal government cannot interfere with a doctor's prescription for medicine that could ultimately be used for euthanasia. You have human rights cases coming out of Gitmo, and whether prisoners at Gitmo can be, and do have constitutional rights. The courts said that they do. You have school rights cases. You have probably I would think that one of the three most important cases to come out of the Roberts Court would be Citizens United versus the FCC. There's a lot of talk of overturning that either legislatively or through more court filings. But currently, that's what created the concept of super PACs and poured more money into the electoral process. You also have, interestingly enough, the National Federation of Independent Businesses versus Sebelius. That's the case that where a Republican Supreme Court, led by a Republican Chief Justice, who was the final vote there, held in place the legislative quote unquote accomplishment of a Democratic president, and that being Obamacare, the Affordable Care Act. But then there was also some limitations put on that with the Catholic sisters, I think it's the Sisters of Mercy, Sisters of the Poor, which were able to get some kind of an exclusion for that. And then you have Burwell versus Hobby Lobby, where Hobby Lobby, a quote unquote closely held family corporation, was successful in arguing that because it is a closely held family corporation, that family's right to freedom of religion meant that they don't have to give out health care in terms of like the abortion day after pill, abortion coverage, and such like that. So again, this is based on the dueling concepts of whether, and this goes back to Dartmouth College versus Woodward, whether a corporation is a person or not, and how many rights do corporations have in their personhood. And then we have the last case there, we have the case that decided that marriage equality was the law of the land of the United States. So just to review, pulling out from all of those 17 courts, these I think are the cases that certainly come up in law classes, in college poli-sci classes, in high school AP government classes. These come up, I mean, these are things that you have to learn in law school. These are probably the most famous cases in American history. I'm sure there are more. I'm not perfect, but certainly Marbury versus Madison and Dartmouth College versus Woodward, McCulloch versus Maryland, and Gibbons versus Ogden. Those are fundamental cases. I think Worcester and Cherokee versus Georgia, those are interesting in terms of the battle between the judiciary and the federal and states' rights. We have the dark stains on our legal history in terms of Dred Scott and Plessy. Fortunately, Brown versus Topeka begins the process of giving and recognizing full citizenship of African Americans, and then with Miranda versus Arizona, the idea that even all people have to have an understanding of their rights before they waive their rights, and so that's where you have to be told what your rights are at the moment of arrest. Loving versus Virginia, the fact that you cannot restrict marriage based on race. Roe versus Wade legalized abortion. Regions of California is what affirmed affirmative action, although it eliminated quotas. Lynch v. Donnelly is the Kresch case. Bush versus Gore decided the presidential election in 2000. The Rumsfeld case is a civil rights case for the prisoners of Gitmo. Citizens United, super PACs. Snyder versus Phelps, I don't think I mentioned that one earlier. That's the case where, sadly, there was a soldier who was being buried, and the Westboro Baptist Church protested this soldier's funeral. And not that it matters to the story or not, the soldier was not gay, but Westboro Baptist Church was protesting and claiming that the gay rights in our country is what caused U.S. soldiers to die in the conflicts of Iraq and Afghanistan. Very disturbing case. But the court upheld the First Amendment rights of the Westboro Baptist Church. And then you have Burwell versus Hobby Lobby, the limitations of Obamacare, and then the legalization of same-sex marriage in the United States. So these are some of the cases I pulled out. There's a very good chance that these would come up, again, as I said, on high school history tests, U.S. government tests, AP government tests, college poli-sci classes, and first year law school. So hopefully these help you. And finally, I think these are probably the six most important Chief Justices to know by name. John Jay for being the first Chief Justice, the great John Marshall for everything, Roger Taney because of the Dred Scott case, and then on the right hand side, some of the more recent ones, President Taft being the only person to serve as both President and Chief Justice, the great Earl Warren, and again, I would think he's probably the second most important Chief Justice in legal history of the United States, and there's John Roberts, our current Chief Justice. So thank you, and I hope that this was interesting to you. This is what the court looks like today. So you have the Chief Justice center front row, and then you have Sotomayor, Neil Gorsuch, the junior most member, Kagan, Alito, Ginsburg, Kennedy, Thomas, and that is the current court as it's constituted today in the month of April, the year 2018. Those judges are important to know also in testing, as they are the most current associate justices, but the longer you go back in history, the less important the associate justices become, and the chief justices become more important. And again, we refer to courts as they are led by the Chief Justice, even if the Chief Justice is his ideology is not the majority of the court. So hopefully this was a quick little primer on the United States Supreme Court and the Chief Justices. Thank you very much.